This is the Sheldon Matter. This is the MDA for the post office, which we've unsuccessfully tried multiple times to get approved by the court, by opposing counsel, and by the post office. The one we have now, the post office isn't going to take, even with their new forms or whatever they have that we filled out, they still say it's not sufficiently clear as to what the division is. So, and I've proposed a couple MDAs, and they're not agreeable to Mrs. Shelton. So I think we'll just have to have a hearing, and the court will have to decide what the MDA or what the quadro should say based on what was in the MDA, the original quadro that was submitted decades ago, probably now.
2004.
Yeah, just is not sufficient for them to act on. And I proposed a couple. I've submitted a couple to the court, and they've rejected them. So I think we'll just have to have a hearing, and the court can hear the facts and decide, and look at the MDA and decide what the language as far as the percentages and the years of marriage should be in that order, in that quadro, for them to resubmit it to them. Hopefully this time they take it.
Not sure how the order of dismissal came about, but Ms. Roberts, you want to? All right.
Your Honor, this matter, I represented Mrs. Now Mrs. Landfair, the then Mrs. Shelton, in a divorce in 2004. The final decree was entered by Judge Birch on 11/14 of 2003. And in that, we incorporated a marital dissolution agreement. This matter has been filed at least 3 other occasions. Initially, again, as I said, the divorce was granted in 2003. I did a qualified domestic, there was a pursuant to paragraph 5 on page 4. Husband shall receive, as his sole and separate property, free and clear of any claims of the wife, 50% of the wife's thrift savings plan as of June 17th, 2003, including any and all interest that has or may be earned on his portion. Additionally, husband will receive 1/2 of the wife's retirement account through the United States Postal Service for the time period the parties were married. The wife shall execute any and all necessary documents necessary to effectuate this transfer, including but not limited to a qualified domestic relations order. That matter was entered, and Mr. Maher represented the plaintiff, and I represented the defendant, who was Ms. Landfair. After that point in time, Your Honor, when the decree was entered, we never received any QDRO that my client was supposed to execute. So, and then it was, if I could, in 2004, in March of 2004, after I said the divorce was granted in November, in March of 2004, that's when we received a qualified domestic relations order. Mr. Maher, I believe, forwarded that to us, and it is one that says that qualified domestic order stating the party's name, and it's the Civil Service Retirement System and Federal Employees Retirement System with the account numbers. And it rightfully says that Mr. Danny Charles Shelton will be awarded an amount equal to 1/2 of the monies contained in the Civil Service Retirement System and Employees Federal Retirement Account as of June 17th of 2003. That order, that was signed again by Judge Birch. No, Judge Martin signed that. A certified copy was obtained, and I personally sent the certified copy to the Office of Personnel Management, who was the administrator at the time in 2004, and that is on file where they did receive it in 2004. We did nothing else involving in that case. Mr. Maher then in 2015, possibly 2014, filed a petition seeking contempt sanctions against my client and alleged in 2015 that my client was in willful and deliberate contempt of the orders of this court, criminal and civil contempt, stating that she had failed to execute any qualified domestic relations order, and asked that she be incarcerated until such time that she does it, albeit I filed a Rule 11 sanction in that matter, notified as I was required under Rule 11, I forwarded that to Mr. Maher and advised him that his petition was without merit, and gave him the requisite amount of time to amend. He then filed an amended petition on October 26th of 2015, wherein he struck the contempt sanctions and asked that in the petition for the court to enter an appropriate qualified domestic relations order, and then asked for pre and post judgment interest. That matter was then done. I timely filed a responsive pleading to that matter. That matter languished for a while. We had a couple of show causes on it. I filed a motion to dismiss that matter for failure to prosecute. That matter came before the court on September 14th, I think September 14th of 2018. And Mr. Maher was not present at the time. Or at that time he did appear on that date. And Your Honor gave him 15 days to prepare a qualified domestic relations order that accurately reflects the ruling of the court. And at that point in time, Mr. Maher had drafted a qualified domestic relations order without the requisite dates. It just gave him half of her retirement account, which she continued to work at the Postal Service after the divorce. I refused to sign that and notified him in writing and via email that the order was incorrect and that I would not sign it because it had the time frame of he would get one half of her entire account, and the contingency was from the date of the marriage to the date of the divorce. So I refused to sign that. Your Honor continued that matter until December 5th, and I appeared on December 5th. And at that point in time, and asked that the matter be dismissed, and to my knowledge, it did. And then Mr. Maher then filed, again, I believe, if I'm not correct, a motion to amend.
The order that dismissed the action was entered on December the 17th, 2018. On February the 21st of 2019, the motion to amend the qualified domestic relations order was filed by Mr. Maher.
Right. So again, the issue is that the order clearly states that his client is entitled, but that we are only to sign the documents. When I got the show cause yet again from a filing, as I dealt with it from 2015 to 2018 with no action being taken, and it got dismissed. Then it got filed again on just a motion, not a petition, a motion to amend the QDRO that was filed. It again languished and has done that. And when I got the show cause, I simply went through the show causes and forwarded motions of non-suit. And I believe that's what, to a long way answering your question, Your Honor, is that I prepared that and forwarded it over here because this matter had already been dismissed on another occasion.
Well, then Mr. Maher has filed a subsequent motion to amend on the 21st of February, 2019. He also filed an additional motion to amend the qualified domestic relations order on October the 24th of 2019 that was identical in its language and provisions to the one filed before. Then there was a show cause order that was entered September the 18th of 2020 saying that there was, the show cause as to why it shouldn't be dismissed for failure to prosecute. On August the 6th of 2020, Mr. Maher, on behalf of Mr. Shelton, filed a motion to set. And there was a notice of hearing filed on September the 9th of 2020 that Mr. Maher filed, and he requested to have that heard by Zoom or other electronic means. Your motion to strike the notice of hearing and a motion to amend the qualified domestic relations order was then filed on September the 11th of 2020. Then Mr. Maher filed a separate petition to enforce marital dissolution agreement on April the 11th of 2022. An answer was then filed by you on behalf of your client for April 28th of 2022. An order was entered on the 18th day of September 2020 that for some reason was not entered until April the 11th of 2023 that reflected the hearing on September 18th of 2020, dismissing the motion to amend. There's a notice of hearing on a motion to set that Mr. Maher filed for on September the 7th to have the hearing on September the 7th of 2023. Another motion to set a final hearing was filed July 19th of 2023. A notice to strike from the docket. The petitioner, Danny Charles Shelton, by and through his attorney of record, John T. Maher, requests the court to strike his final hearing, presently set for November 28, 2023, until further notice from the parties. A show cause order was then entered August the 5th of 2025. Show cause why this should not be dismissed. Setting the hearing on September the 18th of 2025. Motion to set was filed by Mr. Maher on August the 19th of 2025. And the order of dismissal that this court signed was on the 25th day of August, based on the fact that this case had been dismissed on a number of other occasions. Now Mr. Maher is here today asking to set aside the order of dismissal. So that is a chronology of this case, as best I can see it. Mr. Maher, the motion to amend that was originally filed was dismissed, and more than 30 days elapsed before another motion was filed in the case. I have considered this matter to be concluded by my denial or my dismissal of that matter, and I don't think that that is anything that can be resurrected by simply filing a new motion to amend, or can't amend a petition or amend a final decree years after it was entered. I think the only thing that I can say is the final decree provides for a qualified domestic relations order. We previously put an order down that says that you would provide counsel for Mrs. Shelton with a qualified domestic relations order that correctly set out everything, and it is, in my opinion, your responsibility, and I do not find that there is any basis to set aside my orders. So.
And Your Honor, just again for the record, if we have a qualified domestic relations order approved by the Office of Personnel Management that reflects that he gets the thrift plan through the June date and the retirement through the divorce date, that's all that needs to be done, but it was a divorce on the grounds of irreconcilable differences, so nothing can be amended because it was irreconcilable differences.
Well,
So
you can't amend a final decree if it was irreconcilable differences, but you can submit yourself, you can draft an order, a qualified domestic relations order that correctly sets out all of those provisions, and then follow with the court. I'm not going to open if I did what you're asking me to do, which is come in and have a hearing to determine something, then it's no longer an uncontested irreconcilable differences divorce. I would have to set aside the final decree of divorce, leave these parties married after all of these years, And at that point in time, I would have to then conduct a hearing. In my opinion, the better way of doing it, you've got an order down that provides that a qualified domestic relations order was to be entered. I don't understand exactly why that would require any kind of discussion other than the fact that there are dates that are set forth in the final decree that have to be dealt with. And this court is not going to reopen this case by granting your motion to set aside and have a hearing on this issue. So your motion to set aside is denied. You still have the remedy of drafting a marital dissolution agreement. I'm sorry, a qualified domestic relations order that reflects what was agreed to in the marital dissolution agreement, and that Ms. Roberts and her client would have to sign off on.
And just so I can clarify, Your Honor, the last thing I filed was not a motion. It was the petition to enforce the language that was in there, not to modify, not to change, a petition to enforce, knowing what the court's prior rulings were that I could not, it could not be amended. We just needed to enforce it. And we just want the court to enter an MDA, and I supplied an MDA to the court, and the court did not sign it with the dates in it. So I will resubmit that, but I would posit to the court that I filed a petition to enforce was the last thing I filed, knowing that the motions, as the court had prior said, were probably the inappropriate remedy to do in this situation. I sent the MDA, or the Quadro, they wouldn't sign it.
Right.
So then my only remedy to that would be a petition to enforce.
And Your Honor, if I could, the motion I filed, when he filed the motion, I filed a counter motion to dismiss because it wasn't properly before the court, because the case was not open and you could not reopen a case on a motion. That was granted, and he filed a petition, and we filed an answer. He filed a motion to set. It was set for hearing, and then he entered an order striking the final hearing. We do not dispute the language of the final decree, which incorporated the marital dissolution agreement. The only thing that we're saying is we want a qualified domestic relations order that is approved by the Office of Personnel Management through the United States government, that is the plan administrator for the United States Postal Service, and have it pre-approved. And once it's approved, the court can enter it. But this incessant going back and forth with a non-approved QDRO for 2 retirement accounts is the issue. He had the obligation to prepare it. We only have to sign it. When we are presented with one, it will be signed.
Why haven't you submitted a?
I have. I've sent her the Quadro with the language. She would not sign it, and so that's when I filed the motion.
Well, of course, she says that you had it at 50-50, which is not what the final.
Your Honor, that's true. That was the first time. That was the motion where the court reset it and then eventually dismissed the motion.
So have you prepared one that accurately reflects what the final decree says?
We believe so, and we submitted it to Ms. Roberts, and we submitted it to the court, and the court would not sign it.
I'm not going to sign it without both sides setting off.
I understand.
Ms. Roberts.
And so, and today she's saying I have to get something from the Office of Personnel Management, which is the first time I've heard this, a letter from the Office of Personnel Management saying that order is approved. So if that's what the court's saying I got to do, I can try to do that. I don't know if they'll pre-qualify it, but I'll try. They're very difficult to deal with.
Well, I'm going to pass your motions to set aside the final decree, or set aside my order of dismissal to allow you to try to see if you two can't. It sure seems to me like there ought to be a method by which you don't have, it doesn't require a hearing on my part. If I have a hearing, I'm going to order that you enter a Quadro according to what the terms of the final decree are. So it just seems disingenuous for me to have a hearing on a case where that is going to be my ruling at that point in time. So I'm going to pass your motion to set aside the order to allow you to see if you can't get this resolved by some sort of an agreement that accurately reflects what the court had previously ruled in the final decree. And after that, I will consider whether or not to reinstate your petition if you're not able to reach it. But right now, I don't think there's any basis for setting it aside, but I'll pass it and let you two do it. We're going to take a morning recess for 15 minutes.
Thank you, Your Honor.
All rise.
Oh, excuse me. Okay.
Looks like everybody's lost interest and left, so. You want to check and see if the attorneys need more time or if they're ready to go? All right, so does she need more time then? Okay. All right, the Ferguson case is under discussion, which would then leave us only with Dodd to conclude. So I'm going to step back off. The lawyers have requested an opportunity to continue discussions. All right, I'll step off and we'll come back when they tell me they're ready.
Rise.
Keep your seats. October the 26th, March. March. Was it February? March 26th and 27th, I've said First Federal versus Cunningham. April the 1st and 2nd is Cunningham Construction versus First Federal.